A lease is a formal agreement in which one party, lessor, gives another party the lease. The use of property or asset for predetermined amount of time, usually in exchange for money. The lessor retain ownership, but the less is granted permission to use and occupy the property as long as certain conditions are met. Lease term. The precise amount of time that lease is in effect. Rent payment. Lease pays the lessor a regular fee, monthly rent. The property is put to determine use business, legal conditions, obligations, and limitation. No subleasing are all part of the contract. The lessor may terminate the lease, evict the lease from the property, and take legal action to recover overdue rent and damage if the lease doesn't pay. Yes, subleasing a section of the property without Mr. Santos' permission, Ms. Ramirez broke the terms of contract. Article 1659 of the Philippine Civil Code states that a list cannot assign to list or make amendments without the lesson's approval. Consequently, she committed a violation of contract when she subleased without authorization. Yes, Mr. Santos has the right to end the lease because it was broken. If the lease disregards the terms of the lease, such as the ban of subleasing without permission, the lessor may end the lease in accordance with Article 1662 of the Civil Code. Beginning on January 1, 2003, Ms. Ramirez signed a 2-year commercial lease agreeing to pay 25,000 a month in rent for the use of property as a boutique clothes store. The lease especially forbade subleasing without Mr. Santos' approval. Because Ms. Ramirez broke the condition of the lease by subleasing a section of the property to a friend without getting his permissions. She maintained the sublease did not go against the lease's primary objective and even increased the boutique's visibility, which benefited the company. Ms. Ramirez was forced to leave the property and pay 2 months' rent as a damage after the court decided in favor of Mr. Santos, allowing him to end the lease. Legal basis: non-compliance with lease terms and subleasing without authorization, as defined by Articles 1659 and 1662 of the Civil Code. Yes, because Ms. Ramirez broke a specific and unambiguous clause in the lease agreement that forbade subleasing without the lessor's approval. The court's ruling is just. The durability and predictability of legal agreements depend on the provisions of the contracts being respected. Yes, since it violated a crucial requirement, it was a major infraction. However, if Ms. Ramirez had been prepared to end the sublease freely and engage in sincere negotiation with Mr. Santos, that matter might have been settled without the need for court involvement. Before engaging into any sublet, she might have requested Mr. Santos' written consent. Before making action that would have an impact on the property, she should have carefully read and comply with the condition of the lease. It emphasizes how legally binding and obligatory written agreements are. Even with the best of intentions, breaking agreements can have legal repercussions. It emphasizes how important openness, communication, and legal knowledge are in contractual arrangement. According to Article 1659, a lease cannot assign the lease or make changes without the lessor's approval. In this instance, Ms. Ramirez subleased the property without Mr. Santos' consent, which was a blatant violation of the lease agreement. One defense would be that the sublease improved the business and did not alter the property's primary purpose, which would have indirectly benefited the lessor. This defense, however, would be ineffective because the contract especially forbade subleasing, which means that consent is legally required regardless of the result. In the other party does not carry out their end of the bargain, Article 1191 gives one party the right to terminate the agreement. In this case, Ms. Ramirez broke her contract by subleasing without consent, while Mr. Santos met his by delivering that lease space. Due to this violation, Mr. Santos was able to terminate the lease and pursue damages as allowed under the reciprocal obligation concept. Yes, things might have turned out differently. Ms. Ramirez could contend that subleasing was not contractually prohibited in the absence of an explicit ban, and Mr. Santos might not have had the right to end the lease. The court would then need to determine whether the sublease significantly altered the original agreement terms of or intent.